I've got a really important question for you. What happens if you don't follow the doctor's instructions and now there's a delay in diagnosis leading to significant injury? You want to learn what happens? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. So now, if for whatever reason you don't follow the doctor's instructions, and now as a result of that, your condition is not timely diagnosed, and when it is finally diagnosed, now it is advanced and very significant, can you go ahead and bring a lawsuit against the doctor who you believe caused you harm? The answer is you can, provided that we can show that, number one, there was wrongdoing, number two, the wrongdoing caused injury or was a substantial factor in causing your injury, and number three, that the injury is significant and or permanent. All three of those things have to be confirmed by a doctor who has either treated you or reviewed all your records. So now, here's the scenario. Let's assume you have a valid basis for a case. And let's also assume that you did not follow the doctor's instructions, whether it was to take certain medication or whether it was to follow up in a specific time period. And now, as a result of that delay, you now suffered significant injury. What does that mean if you didn't follow the doctor's instructions? What it will mean is that if you are ultimately successful in showing to the jury that you are more likely right than wrong, that the doctor's carelessness caused you harm, now the jury will also look at your own carelessness and your own negligence in failing to follow the doctor's instructions. And then they will have to come up with a percentage to determine how much you are partially at fault and compare it to the doctor and determine how much the doctor is partially at fault. And now, if the jury gives you compensation for the harms and injuries you suffered, the amount of that compensation will be reduced by the percentage that the jury feels that you are partially at fault. And that could be significant. So now, why do I share this great information with you? I share it with you because there are instances where you, the patient, the injured victim, will have contributed to your own injury. And now some people may be thinking, hey, can I still bring a lawsuit? Will I still be able to recover compensation? The answer is you may, but you may also be found to be partially responsible. So why do I share this great information with you? I share it with you to give you an insight and an understanding to what goes on in evaluating a medical malpractice case here in the state of New York. You know, I realize you're watching this because you probably have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.